Okay, so let's recap the conflict. The William Marbury, it appears that the only way that he can get the justice that he's entitled to is to get this one particular kind of legal order, a writ of mandamus. And the only court that he can go to get it is the Supreme Court. And the only way he can reach the Supreme Court is through a case of original jurisdiction. Don't go through the trial courts, and then if you lose appeal to the Supreme Court, go straight to the Supreme Court for a case that begins and ends there. Except the problem is, what set of instructions told him to go get a writ of mandamus with the Supreme Court? It was a law that was passed by Congress, and yet the Constitution describes the court's original jurisdiction and doesn't include anything that allows the Supreme Court to hear cases through original jurisdiction that involve cabinet ministers and writs of mandamus. But Marbury says that's not a problem. This is sort of the way that Marshall is paraphrasing Marbury's argument. It has been insisted by Marbury's attorneys that the clause assigning original jurisdiction to the Supreme Court contains no negative or restrictive words. In other words, when we were over here, there's nothing in this statement that says in only cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction and no other kinds of cases, right? There's nothing in here that says that it might be some of the kinds of cases that the court can hear on original jurisdiction, but it's not the only ones. So, therefore, Congress, but that's what they mean by legislature, not a state legislature, Congress. Congress they still have the power to assign other kinds of cases to the original jurisdiction of the court. And Chief Justice Marshall is going to say, no, 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 no. If it had been intended to leave it up to Congress to decide what kinds of cases belong to the Supreme Court and other cases belong to the lower level courts that get appealed to the Supreme Court, and you can just divide it up according to the will of Congress at the time, then why not just have stopped after you said the general kinds of cases that can go to any kind of federal court? To specify that some kinds of cases go to the Supreme Court on original jurisdiction would make that part of the Constitution mere superfluous. In other words, it makes those words useless. You need to write this down. If there is any one thing that defines John Marshall's philosophies, and we're going to read a bunch of John Marshall cases, is he does not like the idea of a particular part of the Constitution being rendered useless or being rendered duplicative, right? So here's what he means. If Congress has the power to decide which kinds of cases end up before the Supreme Court over original jurisdiction, right, then why write this entire section? The only thing you would have needed to write is, hey, these are the kinds of cases that can go to federal court as opposed to state courts. And then you could just end that part of the Constitution, right? And then Congress would decide, okay, how many of these will start with the lower courts and then get appealed? How many of them will begin with the Supreme Court and end with the Supreme Court? If you accept William Marbury's argument that Congress can tack on other things, then it makes this part of the Constitution useless. Or at least he claims it does. We'll talk in class about whether that's a good argument or not. So yeah, what this means is why specify any jurisdiction if Congress can make it all up? Like I said, I don't know if I buy this argument, right? One possibility, to prevent Congress from not giving original jurisdiction to the Supreme Court over disputes between two states, disputes involving foreign ambassadors, et cetera, et cetera. So Congress still has some choice, but not total discretion. This rebuttal from Marshall, it would have been useless to have proceeded further. No, there is a use to it. It gives Congress some discretion, but not total discretion over what kinds of cases should begin with the lower federal courts and which cases should begin and end with the U.S. Supreme Court. But here we are. We have a situation where John Marshall thinks that Congress had no power to tack on additional grounds for the Supreme Court's original jurisdiction. So there is a conflict between what Congress has written as an ordinary law and what the U.S. Constitution says. So which law is going to prevail? Well, it's going to be the Constitution. That part of the Judiciary Act is going to be struck down, and this is the first example in Supreme Court history of judicial review. So why? Why would the U.S. Supreme Court have this power? Because other countries' constitutions make it very clear if their courts have the power to strike down laws passed by their parliament or by their Congress or whatever, right? It is not at all clear in the writing of the U.S. Constitution that courts have this power. But Marshall is going to claim it anyways, and he's going to provide, at least from what I recognize, 7 different reasons why the Supreme Court should have this power. Let's go through them all. Number 1, the powers of the legislature, and again, by legislature, he means Congress, the legislative branch, not a state legislature. The powers of the Congress are defined and limited, and the distinction between a government with limited and unlimited powers would be abolished if we let Congress do whatever he wanted, right? It's akin to saying that Congress can do anything that it wants so long as it isn't directly forbidden by the Constitution, and that's not true. As we're going to get into in greater detail in future cases, Congress only has power over the specific kinds of cases, or the specific kinds of power and like lawmaking abilities that has been granted to it by the Constitution. And now you're saying, oh, well, you don't need permission from the Constitution, which is how it's supposed to be. Like, all you have to do is not have to beg for forgiveness. And so long as it's not forbidden, Congress could do anything. No, 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 no. The whole point of having a federal government the way it is to have a government with limited powers. The federal government can only do those things that the Constitution lists, not all those things that the Constitution says the federal government can't do. The second thing that Marshall says is the Constitution is either the supreme law of the land or it is an ordinary law on par with, ordinary laws passed by Congress. And that can't be true. We know that the Constitution is the supreme law of the land. So we can't let Congress sort of like take the Constitution down a peg by refusing to obey the commands in the Constitution. It just ignored Congress when it was writing the Judiciary Act and setting up the powers of the federal courts, it just flat out ignored the language that was contained in the Constitution. And Congress was trying to take the Constitution down a peg, and we can't let that happen. Why? Because it is emphatically the province and duty of the judicial department to say what the law is. If there are 2 laws in conflict with each other, the courts must decide on the operation of each. Resolving conflicts between laws is just what courts do. There's no significant difference between this kind of case and a kind of case that you might see on like a murder mystery show where somebody's rich uncle, is about to change his will. And then he gets murdered, right? And there are like 2 different versions of the will that pop up. And you have to go to court to decide like which version of the will, the one that gives all the money to the, young trophy wife, or the version of the will that gives, money to a charity. Which version of the will is the legally binding version of the will? You go to court to decide that. Right? Because you have 2 wills, in conflict with each other. This case is no different. It's just that one of the kinds of laws is part of the Constitution, and the other law is a law passed by Congress. And we know that federal courts are allowed to look at the Constitution and have that be a source of law around which there might be a conflict with other laws. In other words, the U.S. Supreme Court actually doesn't have the power to cases arising about wills, after rich uncles die. But they do have the power the U.S. Supreme Court does have the power to cases arising under the Constitution, involving constitutional issues. And what Marshall says is, could it be the intention of those who gave this power to say that in using the Constitution should not be looked into? No. The Constitution says federal courts have the power to hear cases involving the Constitution. So if courts resolve conflicts between different kinds of laws, shouldn't one of the laws that you should take as a potential source of conflict be the Constitution? And in Marshall's mind, the easy answer to that question is yes. Fifth, in other words, think of how backwards this quote from Marshall says, think of how backwards our system would be if federal courts didn't have the power of judicial review. For instance, the Constitution says that Congress can't pass a bill of attainder or an ex post facto law. A bill of attainder is basically, instead of you getting hauled into court and put on trial for murder, and you're presumed to be innocent, and the prosecutor has to prove that you are actually guilty beyond a reasonable doubt. A bill of attainder simply says, the Congress is going to pass the William Blake is Guilty of Murder Act of 2024 and automatically punishes me for what the sentence is for murder. No trial, no evidence. You are just ordered to go to prison because you've been convicted of a crime via a law. Not a law that defines what murder is. No. It's a law that says, such and so person or small group of people is guilty of this crime and must be punished, right? So that's something that they did in England, and so we didn't want that to happen in this country, so they wrote that into the Constitution. Ex post facto laws are laws that this is an example of when you try to punish someone for something that they did when that conduct was still legal. So let's say for some reason no one ever noticed that punching someone in the face is legal in the state of Maryland. And just to prove a point about what ex post facto laws are, I punch one of you guys in the face. And then, the Baltimore Sun reports about it, and I get everyone is all up in arms. And the Maryland General Assembly, later this year, passes a law that says, yes, punching someone in the face is assault, and you can go to prison. And then they come and try to arrest me, not because I hit someone after it became illegal, but because I hit someone while it was legal. That's an ex post facto law. You shouldn't get punished for something that was legal, even though afterwards it became illegal, right? And you shouldn't, if you're going to be convicted of a crime, it should be in a court of law, not because Congress says that you are a criminal, right? So what would happen if Congress passed a bill of attainder or, prosecuted someone under an ex post facto law? Should the court condemn to death someone who has been a subject of one of these unjust things? Even though the Constitution says people shouldn't be treated like this. It would be completely backwards. Sixth justification. Remember, judges are like presidents, are like congressmen, are like, frankly, governors and state legislators and everybody else. Your oath of office, everyone has to take an oath of office if you're an elected official, and part of that oath of office is to preserve, protect, and defend the Constitution of the United States. And what Marshall basically says is why should judges tolerate violations of the Constitution when they've just pledged to defend it? And then finally, what Marshall says is it's not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is mentioned, and not the laws of the United States generally, but those which shall have been made in pursuance of the Constitution have that rank. The text of the Constitution basically contemplates that some federal laws might not be consistent with the Constitution. And here's the part of the Constitution that Marshall is referring to. It's Article 6, the Supremacy Clause, which states, "This Constitution and all federal laws which shall be made in pursuance of the Constitution," right, which I think you could argue means made in consistency with the Constitution, shall be the supreme law of the land. So the law gets struck down, and what is the sort of the end result of the case? It actually ended up being praised by newspapers from both political parties. So the Jeffersonians were thrilled that a whole bunch of Federalists got denied officeships. But the Federalists were also happy. Why? Because they knew now that the U.S. Supreme Court had the power to strike down unconstitutional laws, and maybe they would find a bunch of Jeffersonian party laws that new Congress was going to pass. Maybe they would strike those laws down. Marbury gave up. He never served as a justice of the peace. Jefferson himself never publicly criticized the decision, but privately he hated it because he knew that Jefferson didn't want the federal government to be as powerful as the Federalists, and he knew that federal power would grow if federal courts had the power of judicial review. So, now that we've gone over everything, I want you to, here are some questions that might be fair game for one of the 8-point short answer questions on quiz 1. And we'll talk, if you don't have an answer to these now, it's fine. We can talk about them in class because they're also kind of good discussion questions. Like, we went just through like 7 different arguments for judicial review. And some of them I think are more persuasive than others. And so, like, what sort of weaknesses do you see in Marshall's justification for judicial review? Another thing, or sort of a variation on that question, is do Marshall's arguments for judicial review seem stronger when federal judges are striking down state laws as opposed to federal ones? Again, we'll get into this a little bit more in class, but here's why I'm asking that. So they say that the Constitution is the supreme law of the land. It's at the top of our legal food chain, right? And then what it says is the judges in every state judges, must be bound by the U.S. Constitution, even if their state constitution or their state laws say something to the contrary, right? So you might claim that because you have a clear sort of legal hierarchy, and you tell judges, at least state judges, that the U.S. Constitution must trump anything in a state constitution or a state law that runs to the contrary. But there's nothing in here that says that any federal law that runs to the contrary of the U.S. Constitution is something that judges must not side with, and instead of siding with the contrary laws, must side with the U.S. Constitution. So we can talk about that in class as a discussion point. And then finally, there's a way that you can think of Marshall's opinion in this case as being written backwards. Because here's the thing, guys. You, as a judge, you don't ever want to decide anything more in the case than you absolutely have to in order, the duty of a judge is to decide the bare minimum number of issues in a case to get it resolved. And the way Marshall goes is 1, 2, 3. Does Marbury have a right to this commission? Do the laws afford him a remedy? If that is that remedy a mandamus issuing from this court? The only thing that the court had to decide was, does the U.S. Supreme Court have the power to issue a mandamus via original jurisdiction? If that had become number 1 instead of 3, and the answer no, Marshall doesn't need to write any of these parts of the opinion. So why did he flip it? Why did he go 1, 2, 3 when really he should have gone like 3, 2, 1? And the reason is he wanted to show, he was hoping that ordinary people were going to read this opinion and would basically, as they read through the beginning parts, come to the conclusion that Jefferson and James Madison, as Secretary of State, were being complete jerks and acting, unjustly and illegally, but the poor Supreme Court doesn't have the power to force them to do their jobs. That's why he wrote it 1, 2, 3. But if you wanted to write a a more responsible judicial opinion, you should have gone 3. And then once you saw the answer to that was no, there's no need for either of these other sections. So that's about it. I hope you guys enjoyed it. I hope you've been asking questions. If you have any extra questions, I'm happy to answer them in class.